Hello everybody, Stephen Bush back with you from the Bush Law Group, talking about post-loss obligations. And our first post-loss obligation that we're going to dive into today is going to be the prompt notice requirement. In other words, the policyholder has a duty under the policy to timely report any loss. So, what does that mean? Well, that's a good question. And in some jurisdiction, it means different things. But first, let's look at what a Hartford policy says. It says, as soon as practicable, after any loss or damage occurring under this policy, the policyholder is required to report it. So that language again is as soon as practicable. Now, you're going to see different policies with different language, and that's okay because that portion of the contract, all right, the insurance contract, is called prompt notice. And it's prompt notice for a reason. Because if the policyholder delays in giving prompt notice or timely notice of the loss, then in almost every jurisdiction that I've looked at, the failure to give timely notice is a presumed prejudice to the insurance carrier. So what does that mean? That means that but the failure to give that timely notice, because there was time involved in between, all kinds of things could have happened. Someone else could have gotten on the roof. There could have been another storm. All of this prejudiced the insurance company in their investigation of the claim. So we don't want that to happen. So if you're out in the field and you know that a customer, client, has a loss that is a true loss under the policy, they should report it timely and quickly. Now, in most jurisdictions, again, the issue of whether the insured or the policyholder provided prompt notice creates a issue of fact. So what that means is basically that a jury will determine whether or not that the policyholder complied with the terms in the policy. So we couldn't get rid of that issue through summary judgment. We'd have to go to a jury and have the jury to look at it. But failure to give timely notice, and this is what's most important, creates a presumption of prejudice to the carrier. And if the insured or the policyholder breaches the notice provision by failing to give prompt notice, prejudice to the insurer will be presumed. But again, in most jurisdictions, that creates also a rebuttable presumption of prejudice. So what the rebuttable presumption means that the burden now shifts off of the insurance company to the policyholder to prove that the insurance company was not prejudiced. So how do you do that? Well, that's a complicated process, and in a lot of jurisdictions it's different. But one thing that the jury will be looking at is what the insurance policy required. All right, the Hartford policy looked at said as soon as practicable, right? That could be a lot of different situations that could create as soon as practicable. Some say promptly give notice. They straight out say that. Or as soon as a loss has occurred. I've seen that in a couple of policies. All of those are very important languages, so a jury will look at that. They will also look at when notice was provided within the meaning of the policy, whether notice was timely, and whether prejudice exists. In other words, the carrier can't just say, oh, well, we have a presumption of prejudice and we didn't do anything about it, so what? So they can't sit on their hands. There has to be something in there to show that they actually did experience some type of prejudice. So we don't want this to happen. We don't want it to happen to our customers or to our clients. So prompt notice is a post-loss obligation that must be met by the policyholder in order to preserve their rights under the policy. Now, stay tuned, because next we're going to talk about our second post-loss obligation, and that's mitigation of damages. And you're not going to want to miss that one, because we're going to dig deep into that. So I'll see you in just a minute.